Now we're going to spend some time on the major Supreme Court case today. It's the final day of argument for the court, and a big case coming up at 10 o'clock this morning about the Guantanamo Bay detainees. We have two guests at the table this morning. They are Richard Samp, Chief Counsel of the Washington Legal Foundation.
Good morning.
Morning. Along with Stephen Vladik, Associate International Law Professor at the American University here in D.C.
Morning, Paul.
Mr. Vladik, Professor Vladik, you filed a brief in support of the petitioner in this particular case. It's actually a combined case in the court today. Explain what you're asking the court to consider.
Well, there are a couple of different things going on in the case before the court today. We can really probably distill it to three questions. The first is whether the individuals who the government is holding as enemy combatants at Guantanamo Bay, Cuba, have a right to habeas corpus, have a right to bring their claims that they are being unlawfully detained before a federal court. The second question is, if so, does the Military Commissions Act of 2006, which takes away habeas corpus, actually violate that right? Does it actually violate their right to judicial review? And then third, and probably the most important question, but the question really lurking in the background, is the merits of their claims. Are they in fact being held unlawfully? Are there limits on the government's ability to hold these non-citizens as enemy combatants? I think that's sort of behind what the court's doing today, but the first big question is whether they have a right to get into court in the first place.
Mr. Samp, you filed a brief in support of the government. What will the Solicitor General be arguing today at the court?
He will be arguing that the courts have very little role to play in foreign policy in this country. The elected branches of government, Congress and the President, have set up a system to review claims of innocence. These are things called CSRTs that have had hearings for each of the detainees. All of those who were found innocent have already been released or made eligible for release. They also have provided for review of those decisions in a federal appeals court. What the Solicitor General is going to say is that is the procedure that the elected branches of government have decided, and the courts have simply no role in second-guessing those sort of military decisions.
In addition to this discussion, I want to let you know that the court has agreed to release what we talk about around here as same-day audio. They'll basically release an audio feed once the argument is done today. We will take that, put up some pictures, sketches of the players speaking at the court today, and show it all to you on C-SPAN 3 a little bit later. The time is roughly 11:15 a.m. Eastern Time, so the case runs from 10 till maybe about 11, and then we'll get this audio. So on C-SPAN 3, also C-SPAN.org and C-SPAN Radio, you can listen to the combined case on the detainee rights, and then we'll show it to you again tonight, and then on Saturday as part of American the Courts. I want to also point out the phone numbers for our guests. Again, welcoming your calls. Republicans 202-737-0001 on the detainees case, and Democrats 202-737-0002, Independents 202-628-0205. Our guests are Richard Samp, Chief Counsel of the Washington Legal Foundation. He is joined by Stephen Vladik, Associate Professor of International Law at American University. To both of you, to what extent is this a case about executive powers as it is about detainees' rights?
Well, I think very much so. I mean, I think the background question that is at the heart of all of these cases is what limits, if any, are there on the President's power to detain individuals as enemy combatants. Now, the landscape has changed somewhat because Congress has gotten involved through the Military Commissions Act, but there's still the question of whether the political branches can really cut the courts out of the process. And so although the Bush administration's view of executive power is very much behind the scenes in this case, I think that really only gets to the forefront once the court decides whether they really can be cut out of the process the way the Military Commissions Act attempts to do so.
Mr. Samp, executive power here?
Yes, and the court really has already decided the question. 3 years ago, in a case by the name of Hamdi, they decided that Congress has provided the power to the President to detain enemy combatants. So that power is no longer at issue. All that's at issue is, are these people innocent, and do they have the right to bring their innocence claims into the courts? The President and Congress have said, no, they don't.
What does a ruling either way, when it comes down in the spring, mean to the policy, the anti-terror policy in this country?
In our brief in the Supreme Court, we represented a large group of retired admirals and generals. One of the things they said it means is decreased military effectiveness if the rights of these detainees are upheld by the courts. The problem is that if you have soldiers spending all their time out on the battlefield doing witness interviews, taking written statements, and then coming back to court to testify, naturally you are taking away resources from fighting effectiveness. And if that's what we want to put our priorities to, in giving rights to suspected al-Qaeda terrorists rather than effectively fighting the war, then by all means, vote in favor of the plaintiffs.
Stephen Vladik, potential impact of this case?
Well, I mean, I think the impact could be quite monumental. I take slight issue with Mr. Sam's characterization of all of these cases as being covered by Hamdi. That indeed is one of the questions before the court, whether in fact all of the people at Guantanamo Bay can be held the same way Hamdi was held. Hamdi was a battlefield detainee. Many of the people at Guantanamo were picked up elsewhere in the world, in Sarajevo, in North Africa, and so I think that's really the underlying question, and that's why there are implications here. Whether the administration has the authority to hold as enemy combatants individuals not captured by the military, not captured on an active battlefield, I think is really the big question here, and ultimately could be the big precedent that the court sets in this case.
First call for our guest, New York City. Good morning to you.
Hello?
Hi.
Oh, hi, yeah. My question is, if the government loses, will that mean that foreigners, say aliens captured abroad in foreign nations, let's say if their homes are damaged or their personal property is damaged, would they be able to sue the military during wartime? Or, like, if the petitioners, if they win, would their argument apply to enemy combatants who were captured and held, let's say, in Bagram, Iraq?
I think it's an excellent question. The first issue is to whether you can sue the government. I don't believe this case will affect that whatsoever. As to whether those being held in other locations other than Guantanamo Bay are going to be covered, that really is going to be up to the court. They already gave signals in a decision 3 years ago by the name of Rasul that they consider Guantanamo Bay to be the same as the United States, even though it's not. The obvious answer to that would be for the government just to simply hold all these people in Afghanistan. But I am afraid, given the inclination of the Supreme Court to try to exert jurisdiction over everything, that probably they will write their decision broadly enough so that they'll really say, well, basically everywhere in the world is just like the United States.
I mean, I'm not so sure that that's true. I mean, I think much will turn on Justice Kennedy, who really is the swing vote in so many important cases these days, and including this one. And Justice Kennedy has twice written about the special nature of Guantanamo and the likelihood that there are different legal considerations that come into play when we're talking about the Guantanamo detainees. I also think it's important. I mean, the caller asks a very good question. I think we have to be careful to separate out the right of access to the courts, the right to get in the court in the first place, from the merits of the claims that the detainees are making in these cases. It's one thing to say that they actually will win on the merits, that they actually can successfully sue the government. It's quite another altogether to say that it's the courts, first and foremost, who really should have the authority to make that decision.
Moving on to Waldorf, Maryland now for our guests. They are Richard Samp and Stephen Vladik. Go ahead, please.
Yes, good morning, Steve.
Morning.
The guest that supports the Bush administration, sir, why should we believe anything this administration says? They were wrong about Iraq. They were wrong about Iran. They probably were wrong about 9/11 because they got that wrong too. Somehow you guys made it seem like that it was a Democratic issue when George Bush, I believe, was president on 9/11. Let me ask you this. Terrorism suspects in Guantanamo Bay, they've been suspects for, what, 6 years, 7 years now? You mean to tell me they're not terrorists yet? They're just still terrorist suspects? I believe that these people are innocent. And this reason why you guys don't want any habeas corpus with these guys is because if they get the chance to speak in court, you would have serious problems with them being there.
Number one, every single one of the people being held at Guantanamo Bay has been given a hearing, just not a federal court hearing, and many have been released. Secondly, in terms of if you don't trust the executive branch and the legislative branch, we're having an election coming up next year, and the appropriate thing is to vote somebody out of office and have a new administration if you don't like them. Thirdly, in terms of whether or not these people are suspects, that's not the question. We're not charging any of them with crimes. We are charging them as having taken up arms against the United States. They're not being held under any kind of criminal sentence. They're just being detained until the end of active fighting.
Wichita, Kansas, our next call. Hi.
Good morning.
Morning.
My question for both of your guests is tied to the historical context of this case, and I'd like to cite a couple of examples. During World War II, President Roosevelt, we had some German saboteurs who were arrested and caught in the United States. They were rapidly tried and convicted, and most of them were executed. A few years later, then General Eisenhower acquired some illegal German combatants following the Battle of the Bulge, and they were executed in January of 1945 after a brief court-martial. And during the Civil War, President Lincoln had a Order 100, I believe it was, that provided the basis for a number of summary court-martial and execution type situations. These three gentlemen, Roosevelt, Lincoln, and Eisenhower, are all considered very great U.S. presidents, and I'd like your guests to comment about why we should have a different standard for the Islamic jihadists who've killed thousands of Americans. Thank you.
Stephen Vladik, why don't you take that one?
Well, I mean, I think, the precedents are all important, but I think they all go in some different directions. First of all, the Civil War tribunals were actually struck down by the Supreme Court after the war in a case called Ex parte Milligan. And with regard to the World War II cases, the important thing about both the saboteurs case, Ex parte Kieran, and the later case to which I think you might be referring, Johnson versus Eisentrager, which is another important precedent, is that all of the detainees in those cases conceded that they were fighting for the enemy during wartime. The German saboteurs conceded that they were members of the German army. Indeed, they turned themselves in. In the Eisentrager case, the 22 individuals who were tried by military tribunal conceded that they had continued to fight for the Japanese army after Germany had surrendered, which was a war crime. So I think, there are important precedents in American history for trying enemy soldiers during wartime for war crimes. But the real question here is, are these people enemy combatants? Now, the administration says they are, and the administration says we've given them all the process to which they are entitled, but that many of them actually contest that status. And I think that really is the question at the heart of this case. Do the courts get to have a role in saying whether the administration's assertion that these detainees are enemy combatants, are, as the caller says, Islamic jihadists, is actually correct?
We are talking about the Guantanamo Bay detainees cases, actually a combined set of cases at the court today, 10 a.m. Eastern Time. We'll listen to the audio from today's argument during the 11 o'clock hour on C-SPAN-3 today. Our two guests are Stephen Vladik, who is an associate professor of international law at the American University here in Washington. He filed a brief in support of the petitioner in this case. We're also joined by Richard Samp, Chief Counsel of the Washington Legal Foundation, who filed a brief in support of the government. Richard Samp, let me read a quote to you that Stuart Taylor had in the National Journal and to get your take on it. It's right on the screen as well. The process, he writes, is so stacked against detainees as to be Kafkaesque and so unreliable and secretive as to be a global scandal. It has helped to make martyrs of even those Guantanamo detainees who appear to be terrorist mass murderers. Stuart Taylor there, what do you think?
Well, first of all, he can criticize the system all he wants, but many people have successfully navigated that system and have been released based on the government agreeing that there's insufficient evidence to hold them. Secondly, that's what Congress and the President provided for. They provided for judicial review of these CSRT proceedings being held at Guantanamo Bay. So if he is right that some of these proceedings were not conducted in a fair manner, the federal courts will say so and will require a new hearing to take place. What Congress has said you can't do, though, is to go into court, get a habeas corpus proceeding, and have an entire trial that basically ties up the military for years at a time. That's something that historically has never happened.
Caller now from Winston-Salem, North Carolina. Welcome to the program. Caller, turn the sound down, please.
Yes.
Go ahead.
I'm of the opinion that most of this comes from the fact that these attorneys would like to get nice salaries or paid from the government. If they bill the government like they do the normal populace, heaven knows we'd all be bankrupt. Who is paying the salary for all of this when they are out there trying to get these people out? I would just love to ask that question. Thank you very much.
Let's hear from our guests. Any thoughts?
Well, I mean, most of us are working on these cases for free because we actually think that there are important values at stake in this case. We may disagree with our colleagues from across the political spectrum about the right result, but I think we all understand that there is an importance to having the legal issues worked out the way that our system provides for. And I think, that's why most of the lawyers in these cases are working for free. Some of the lawyers are being paid by families of the detainees, but no one's being paid by the government. And I think the assertion that lawyers are getting rich off these cases belies the enormous personal sacrifice that lawyers on both sides of these cases have been making in litigating these very messy but very important cases for the last 6 years.
Mr. Samp, any thoughts?
I agree with Stephen that people generally are not getting paid for this work, but I certainly agree with the caller that one of the problems in this country is we have perhaps too many lawyers, and one of the problems with this case is that with hundreds of lawyers working on it, it has taken a lot longer than it really should.
Raleigh, North Carolina, you're on the air.
Good morning, Steve.
Morning.
I am an attorney, and I have major questions with this whole crazy process. I guess the first one that comes to mind is, what is the burden of proof, and are these detainees being held under the Uniform Code of Military Justice or under criminal laws? The burden generally in the U.S. is you're innocent until proven guilty.
Let me hold you there. We'll get a response, and then you can ask another question.
Okay, great.
Professor Vladik, want to take that?
Well, I think part of the problem in these cases is that the burden has shifted. It's not pursuant to either the Uniform Code of Military Justice or the criminal law. It is a burden that until the Military Commissions Act was basically established by executive rule. The Military Commissions Act does not do much more to clarify that. The burden is on the detainee in these proceedings to show that he is not an enemy combatant. And one of the issues is that the amount of evidence the detainee is allowed to produce, the witnesses the detainee is allowed to call, the type of evidence the government is allowed to use are really inconsistent with the rules that normally apply in criminal and even civil proceedings in U.S. courts.
Richard Samp, what do you make of that point?
Stephen is correct that the criminal justice system does not apply here. There are detailed regulations that the Department of Justice has established, and the Department of Defense as well, for when people can be held, and those are being followed, I think, relatively strictly.
Caller, you got some more?
Sure. Well, then the question is, since we can use coerced statements that I remember hearing, so you can waterboard people, get coerced statements from whatever torture or very severe interrogations that people will admit anything to avoid the pain, you can use that against them. So the question is, it becomes a sham. So this whole situation, if all these guys are supposedly terrorists and jihadist combatants, what evidence is there against them? I think the concept that we're looking at is if you're picked up by the police state, meaning the government, the military, or whoever, get some charges. What am I being accused of? I understand that a lot of people have been picked up by paid informants in Afghanistan, and that hasn't been made public enough. If you're paying guys who's a sheep herder someplace, and he's got a little feud with his neighbor, and he says, "Oh, my neighbor's a terrorist, and now pay me my fee for turning this guy in," and the so-called terrorist is just a sheep herder, and he's thrown into Guantanamo. Nobody ever introduces evidence against him.
How about that point, Richard Samp?
Well, what this case comes down to, who is going to make that decision? Of course we should not be holding innocent people. The question is, though, do we allow the military, with the consent of the President and Congress, to make that decision, or do we allow the courts to second-guess them? The military has released many, many people who they don't believe they have sufficient evidence against. They do believe, however, that the people who are there are the worst of the worst. Now, about 30 people who they've released are known to have returned to the Afghanistan battlefield to fight again against the United States. And that's why we have to be very careful about who we release. Therefore, we certainly don't want the courts getting messed up in this as well.
We've about a half hour left in this discussion with our two guests, Richard Samp of the Washington Legal Foundation and Stephen Vladik of the American University. Professor Vladik, remind us of some of the details of these cases. First, Boumediene versus Bush. What are the facts?
Well, the facts, most of the individuals in these cases were picked up either on the battlefield in Afghanistan or elsewhere in Europe and North Africa, most of them between the fall of 2001 and I think late 2003 is when the bulk of the cases end. And these are cases where the detainees are challenging their ability to get into court to have their claims pressed, to push the question of whether the evidence against them is sufficient to justify their detention as enemy combatants. And in the case of those detainees who weren't even picked up on what we might think of as a traditional battlefield, one of the questions is whether they can be held pursuant to this military process in the first place. Now, the answer may well be yes at the end of the day, but I think really the issue before the court today is whether the courts really do get to assert themselves in answering those questions, or whether they really should just defer to the political branches.
Richard Samp, we talked about Justice Kennedy being a key in this case. What kind of questions are you expecting from the justices to the two attorneys?
I suspect that Justice Kennedy is going to focus very specifically on the facts of this case. He's going to say, what kind of control does the United States have over Guantanamo Bay? And he is one who very rarely likes to admit that the federal courts don't have jurisdiction to decide a question. And so he's going to say, well, if you have brought these people to Guantanamo Bay, you are essentially implying that you will give them protection. And part of the protection that they ought to get is protection of the United States Constitution. And if he asks those kind of questions, that's a bad sign for the government.
Caller from Philadelphia, good morning.
Good morning.
Hi there.
My question is for Mr. Vladik. I'm wondering, these enemy combatants, as he calls them, the battlefield, I don't think they had anything to do with the sheep, as the previous caller said. They were on the battlefield because they were fighting against us. Now, if Mr. Vladik is so interested in getting them their jurisprudence, and I'm not a lawyer, would he be willing to have them stay at his house while they're waiting for their court case? And I'll wait for your reply.
Stephen Vladik.
Well, I mean, my apartment's pretty small, so I don't know that there's room for them. But I think, the bigger question here is, as the previous caller alluded to, at least some of the battlefield detainees, including one of the U.S. citizens held as an enemy combatant, Yasser Hamdi, were not actually captured by our military forces. They were captured by the Northern Alliance, by other militia bands in Afghanistan. And so I think it's entirely right, as the caller suggests, that individuals who are captured by American troops on the battlefield while engaged with our troops can be held as military detainees pursuant to the laws of war. The problem in this case is twofold. First, we're not actually treating those detainees pursuant to the laws of war. And second, there are a whole bunch of detainees, there's a large group of detainees who we didn't capture, or at least we didn't capture on the battlefield. And so I think, I take slight issue with the premise of the caller's question that every one of the detainees at Guantanamo is someone who one of our soldiers captured on the battlefield. If that were true, this would be a very, very different case.
Richard Samp, want to add anything to that?
I think Mr. Vladik's correct that they are not necessarily caught by our troops. I don't think historically that has made any difference. Whether the German saboteurs were actually captured by American troops or, as was really the case, they were captured by the FBI in various cities in the United States, doesn't make them any less enemy combatants.
I mean, I think that's absolutely right, although I think in the case of the saboteurs, they turned themselves into the FBI. They weren't captured. But the question is not whether they're captured, I guess to clarify my statement, not by American authorities, right, but by foreigners who have other reasons for capturing these individuals. It was true for a long time, in the fall of 2001, that the United States was paying a bounty to individuals who turned over terrorism suspects to the American government. I'm not saying that's a bad idea, but I'm saying that we can understand why someone who has a gripe with a local citizen in Anbar province might turn them over, not because they're fighting for al-Qaeda against the United States, but simply because they don't like them. And so I guess the question is, should the government really be able to just point at them and say, yes, we believe you're an enemy combatant, or should the courts have at least some role in judging that after the fact?
Back to the calls. Carmel, Indiana, thanks for waiting. Hi.
Hi, how you doing?
Fine.
I had a question. I heard, I think it's Richard Samp, he was commenting earlier about the election process, and I just wanted to say that my personal belief is that our American vote has been jeopardized by these electronic voting machines, and I think 2004 Bush election was a good example of that. And I just want to encourage that all Americans stand up for our vote and encourage a paper ballot or a paper trail so we can prevent this corruption and prevent these kind of administrations and people being voted into power. And it's really just humiliating, and it's really bad because I live in Muncie, Indiana. I went to school there. The first time I went to vote ever in my life, I went there to vote. and the electronic voting machine was screwed up, and I didn't realize it until I left the voting poll. And there was nothing I could do about it, so I really encourage everyone to push for a paper ballot.
Caller, thanks. Let's move on to Griffin, Georgia. Hey, Griffin.
My question is that if these individuals were caught on the battlefield by Allied forces or by UN peacekeepers or any such who is an ally to the United States during wartime, those people should and could be held, right?
That's certainly correct, although we have a process. The Army has a regulation, it's Army Regulation 190-8, pursuant to which it deals with those individuals that are captured by U.S. military or Allied military forces on the battlefield during wartime. That process hasn't been followed in these cases.
Caller?
If the federal courts have any jurisdiction over the military, why should that even be a question? Because the military is its own branch of everything except to the highest office of the government, as you know, the Defense Department, the President. So how could a federal judge rule in any situation over any military action that is taken upon people who commit crimes against this country?
Richard Sam?
Historically, the caller is absolutely right, that military justice has been a separate system of justice, and the Supreme Court has upheld laws that say that there isn't any appeal whatsoever into the federal courts from the military justice system. Now, in fact, in this particular case, the Congress has permitted military detainees to appeal into the federal courts, but they're just not satisfied with what they've been given. They want even more rights than that.
Although, I mean, the caller rightly extols the virtues of our military justice system, which really is a remarkably powerful and comprehensive system. But I think it's telling that in these cases, some of the loudest opponents of the Bush administration's approach to detaining enemy combatants, to resolving status challenges, have been the military's lawyers. It has been the JAG lawyers who have been really at the forefront of the opposition to these policies, not because they actually represent the detainees, not because they actually believe that the detainees should go free, but because they actually think that the military justice system is in some ways being subverted by the process that is being carried out pursuant to the Military Commissions Act and the various executive orders the administration promulgated beforehand.
Go ahead.
I'm just going to say that's basically not true. There are one or two dissidents within the military justice system who believe that. However, among the many former generals and admirals who we represented in this case were a gentleman who was the head of the military Army justice system for many years, and also the admiral who was head of the Navy justice system. And according to them, in my conversations with them, the vast majority of JAG attorneys think that the current system is just fine.
But I mean, you know, we could probably count up votes and see who wins. I don't think that's really the important point. I mean, reasonable people will disagree about the merits of these cases. That there is dissension internally within the military justice system is, I think, part of the bigger puzzle here and part of the bigger picture, which is the notion that there's an ever stronger argument for the courts to step in and to clarify what the limits are and what the relevant considerations are in all of these cases.
Just a reminder that the court has agreed to release audio from today's argument, so sometime during the 11 o'clock hour, we think about 11:15 a.m. Eastern Time, you'll be able to hear it several different ways. C-SPAN 3 will have it at about 11:15. Also cspan.org and at C-SPAN Radio, so you can hear the full argument, and we'll look to show it to you again tonight on C-SPAN or C-SPAN 2, and we can tell you for sure it'll be on this Saturday night on American the Courts. That's at 7 o'clock Eastern Time right on this network. C-SPAN. Bloomington, Illinois, thank you for hanging on. You're on with Richard Samp and Stephen Vladik. Go ahead.
Good morning. I think C-SPAN, of course, and as well as Mr. Samp and Professor Vladik are providing a very fine public service in holding this discussion. My question of both Mr. Samp and of the professor is this. Would you please tell the viewers your understanding of the decision that's being reviewed by the U.S. Supreme Court today, which I believe, if my understanding is correct, was a 2-to-1 decision issued by the D.C. Circuit Court of Appeals upholding the Military Commissions Act. And I'm particularly interested in there are any comments either one of those gentlemen would care to make with regard to the debate held in September of last year on the at the Senate Judiciary Committee hearing chaired by Senator Specter, on this issue of, or on the issue, one of the issues involved here, concerning the extension of habeas corpus rights to non-U.S. citizens, which Senator Specter favored.
Thanks. Let's start with Stephen Vladik.
Well, I mean, the D.C. Circuit said, as the caller notes, it was a 2-to-1 split. The D.C. Circuit says the suspension clause of the Constitution, the provision that protects the right to habeas corpus, does not apply to non-citizens held outside the territorial United States. Judge Randolph, I believe, was the author of that opinion. Judge Rogers dissented, and what she basically said is it may be true that non-citizens held outside the territorial United States have fewer constitutional rights, but that's a different question from whether they have a right of access to the courts via the writ of habeas corpus. And indeed, you know, the passage of the Military Commissions Act is an interesting part of this chapter. The habeas provision that really is at the heart of these cases was almost cut out of the act. The vote in the Senate to remove the provision lost by 1 vote. And Senator Specter, who was the chair of the Judiciary Committee, who actually voted to take out the habeas provision before voting for the whole bill, voted for the bill even though he was convinced that the